This is a civil matter. This is a civil judgment. And in this judgment, the main point of decision is based on a principle which is called the doctrine of merger. तो अगर आपको पता नहीं है और अगर थोड़ा बहुत पता है then you might get some clarity what this is and where it is applicable. Now, before I tell you about the doctrine in details, let me just tell you a brief facts and the circumstances of this story. So it will help you to relate with the doctrine itself. तो इसमें क्या होता है कि ये जो appellant होता है जिसमें बहुत सारे जजमेंट्स होते हैं जजमेंट और ऑर्डर्स पास्ड बाय ट्रायल कोर्ट देन judgment or order passed by session court and then high court. Now, at one point, what happens is this: there are two, I mean, by virtue of this appeal and the second appeal, more than two orders come into existence. Now, the question is which order to prevail. तो जैसे अगर आपका ट्रायल कोर्ट का कुछ ऑर्डर है उसके बाद आपके सेशन कोर्ट का कुछ ऑर्डर्स है या फिर जजमेंट्स है एंड देन सब्सिक्वेंटली हाई कोर्ट then which one prevails. Now, in case of doctrine of merger, what it says is this: that it is the appellate court whose order or judgment is to prevail. And if you want to understand कि इसका लॉजिक क्या है तो लॉजिक ये रहता है कि अगर आप ये सोचो इन अ सिनारियो वेयर आपके पास एक सिविल सूट है एंड देन देयर आर सेट ऑफ ऑर्डर्स और जज देयर इज अ जजमेंट पास्ड बाय द ट्रायल कोर्ट then the appellate court then the high court. Now you have multiplicity there, right? And अगर सबको इंडिविजुअली ऑपरेट करना है then subsequently there will be more cases because then you look at them as individual सब्जेक्ट मैटर्स एंड उसको डील करने के लिए फिर आप अलग से केस करने जाते हो. सो when you have such a scenario, the doctrine of merger applies, and here you have a brief narrative or illustration of the same doctrine. It says the logic underlying the doctrine of merger is that there cannot be more than one decree or operative order governing the same subject matter. तो अगर सेम सब्जेक्ट मैटर है और ट्रायल कोर्ट एपलेट कोर्ट जज कोर्ट में अपील और सेकंड अपील और रिवीजन जो भी हो अगर हुआ है और डिफरेंट कोर्ट ने कुछ डिफरेंट ऑर्डर्स दिए हैं तो सारे जो ऑर्डर्स दिए हैं वो इंडिपेंडेंटली ऑपरेट नहीं करेगा. देयर विल बी ओनली one single order and that will be the whichever is passed by the highest one. So if it is session, then if there are two orders, one is passed by the trial court and the other is by the session court, then it will be the session. And if again there is one more order passed by high court, then it will be the order of the high court which will be operative, not the trial court or the session court. So that is the doctrine. And here you have a small case which states exactly that, and there is subsequent one more case. It's Kunnayamed versus State of Kerala 2006 SSC 359. So hope that clears everything out with respect to the question what is doctrine of merger. And then अगर आप कुछ similar situation पे है जहाँ पे you have this sort of situation, then you can understand or at least you'll understand which order will be operative or which order will prevail uh, uh, in your case. So that's all for today. If you have any question, you can always let me know in the comment section. Thank you.